Hi, good afternoon, or good morning, rather. My goodness. Welcome to the Legal Issue Committee's final webinar of the fall. We have a fantastic program scheduled for you today with some amazing speakers and some great topics. My name is Jared Eade. I'm a partner at Hall Griffin. I'm the current chair of the Legal Issues Committee. This is actually my last webinar here as the chair. We're going to be shifting over quite soon to Ian Rambaran from Kleindienst, who will be chairing. He was our vice chair this year, which leads me to a couple of important points. Number one is that, I again want to stress this has been a fantastic opportunity to learn some new people in the industry, as serving as chair, serving as the secretary, serving as the vice chair before that. I encourage any of you who are interested in serving on this committee in a leadership role, please reach out to Dustin. If you know somebody who you think would be good to serve in a leadership role on this committee, please reach out to Dustin and let us know. We're currently looking to fill the positions of both vice chair and secretary for the upcoming year, and would love any nominations. We have received a couple of nominations, but before we finalize things, we'd love to get some names in there. Pretty much any input that you have. Some of the important things that we do here on the Legal Issues Committee, beyond simply putting on these wonderful webinars, is also talking a little bit about the Legal Issues Committee conference that is coming up in December. Right now, that conference is scheduled for December 2nd and 3rd in Newport Beach, and it's got a pretty, fantastic cluster lineup, including we've now confirmed the General Counsel of Fannie Mae is going to be there as a keynote speaker, Terry Theologis, as well as Manny Alvarez from the Department of Business Oversight in California. Again, last year I attended, and we had some great keynote speakers, including from the DBO, and hearing their insight and their communications about what it is they're looking at. It's incredibly valuable information, and certainly eye-opening. We encourage you all to attend this year, but more importantly than that, that conference cannot happen without sponsors. The sponsorships are not only a great opportunity for you all to ensure that we have a good conference going on this year, but also next year as well. It's also a great way to put your name out there. Now, I'm going to do a shameless plug here. If you all look in the chat, I'm about to send you all a link. That link is to the CMBA's website that tells you how to sponsor the program, as well as what sponsorships are available. The sponsorships are really, truly affordable. For members, they start out incredibly cheap, and they give you a great opportunity to put your name out there in front of everyone who's attending. I'm actually having my assistant, while I'm on this phone, go and fill out that form so that we as Hall Griffin can sponsor the CMBA conference as well. I encourage you all, while I want you to listen to this webinar, to please click on that link and save it for later, and have it filled out and see what you can do to sponsor the program coming up as well. Speaking of sponsorships, this webinar is not immune to the need for sponsors. We have been lucky this year to receive the sponsorship of Weiner Brodsky Kider. And I'll turn it over to Ken to talk a little bit more about his firm.
Well, thanks very much, Sharon. Weiner Brodsky Kider has, I think most of you know, provided counsel to the financial services industry in Washington and across the United States for more than 3 decades. Our attorneys are sought after for their knowledge, experience, and insight before regulators and courts. The host of issues, from forward to reverse mortgages, compliance, litigation, all of it is something we work on every day. It is our great pleasure to sponsor the California MBA Legal Issues Committee's excellent series of webinars. We want them to remain free to California MBA members, and we want to help in that regard. We look forward to these presentations. Thank you, Jared.
Thank you very much, Ken, for your firm's sponsorship of these webinars. I know it's made these webinars a very interesting and gotten some certainly some great input as well. If you listening out there are interested in sponsoring next year as well, please reach out to Dustin or myself or Ian Rambaran, as he'll be chair next year, and we'll get you all the information on what that looks like. And certainly I think it's, again, a great opportunity to sponsor a great product and again, get your name out there. Speaking of upcoming opportunities for that, we also have, well, not our committee, but the CMBA has a webinar coming up next week on October 22nd dealing with AB5. It's an incredibly important and timely topic. Dustin, I'm going to turn it over to you to not only give a little bit of a preview of that webinar, but also jump us into the legislative report, if you don't mind.
Sure. Thanks, Jared. And we're actually fortunate one of our speakers for that webinar will actually be on the webinar here. Michael Pfeifer will be not only speaking on today's webinar, but also on the webinar next week covering AB5. He'll be speaking alongside John Jaffe with Mayor Brown. And I know that particularly in the compliance and regulatory community, there's a lot of confusion and concern about the impact of AB5, who's covered, who's not, who's exempt, who's not. And I think that Michael and John will do a great job clearing up some of that confusion and sort of giving you a path forward to comply with AB5 now that it's going to be law. And I'll leave it to Michael if Michael wants to add any more to that before his presentation. So I'll jump into the legislative report right now. As you all know, or likely know, the legislature just finished their session for 2019. And just to kind of sort of give you a scope of what the California MBA deals with and what our lobbyists are dealing with every day, in total this year, the legislature passed over 1,000 bills. It was 1,030 bills in 2019. That's not just bills that they considered, that's bills they actually passed. And just to sort of even narrow that further as far as the scope of what we dealt with, in just the final few days of the legislative calendar, because our wonderful legislature tends to sort of wait to the last second before passing a lot of bills. Over 700 of those 1,000 bills were passed in just the final few days. So you can imagine what our lobbyists had to deal with, sort of just a dump of bills that were passed all at the last second. And so I've got good news, however, on a few bills that I'm happy to report on. It's one of those things where sometimes I've got bad news, sometimes I've got good news, and today I'm happy to have some good news. So there were, before I get into AB 25, there were over a dozen bills that related to the California Consumer Privacy Act, the CCPA, that passed last year. And if you're familiar at all with that, you know that it was a bit of a mess from the start. It was passed in haste, and there was a lot of problems with it that I think everyone involved knew that in 2019 we would have to do a lot of work to clarify some terms and just make it a little more workable. So that's been the biggest focus of our group this year, working with the legislative authors to make sure that we do that. We clarify some of those terms in the CCPA. But there was also some, as you can imagine, once you sort of open Pandora's box to adjust the CCPA, there's lots of effort to add some things in there that are not exactly helpful. So I'm happy to report that issues like SB 561, which I don't have on the screen, but that would have created an express private right of action to all portions of the CCPA. And there's a few other bills that would have just made it much more nightmarish than it is right now. And those bills were defeated. So that's part of my good news. And the other part of my good news I've got here, I'll start with AB 25. So AB 25, that's one of our CCPA bills that passed the legislature. The governor signed it, and it does make an important fix to the law by clarifying that employees and job applicants acting in their professional capacities are not classified as consumers under the Act. Under the Act as it is now, the definition of a consumer is any California resident. So without that clarification that was offered in AB 25, the language could be interpreted to include employees and job applicants, which was not the intended outcome of the CCPA. The author of AB 25 reached a compromise agreement with a labor group opposition to get them to take a neutral position on the bill, and the compromise amendments place a one-year sunset on this clarification. So that means there'll need to be additional legislation next year to keep these helpful changes in statute past that sunset date. So in the California MBA, as you can see on the screen, they're supported AB 25. AB 874 is another CCPA bill. This one, again, also the California MBA supported. It was passed and signed by the governor. This expands the exclusions from the definition of personal information by defining public, what if I use my air quotes here, publicly available information as that which is lawfully made available from federal, state, or local government records, and specifying that private information does not include de-identified or aggregate consumer information. So one of the positive changes made by the bill is that the exclusion no longer specifies that in order to be considered publicly available, the information must be used for a purpose that is consistent with that for which it is publicly maintained. So that's a caveat that made the exception largely just inoperative. And again, the California MBA supported it, it's passed, and now will go into effect on January 1. And then finally, this is my not so good news. This one particularly affects those of you on the commercial multifamily side of the business. AB 1482 is a rent control bill, and it's also been passed and signed by the governor. This would prohibit an owner of a residential real property from increasing the rental rate in an amount that is greater than 5% plus the percentage change in CPI, cost of living, or 10%, whichever is lower, more than the lowest rental rate charged for the immediately preceding 12 months. So it definitely puts a cap on increases in rent. And the one sort of sliver of hope here is that we were successful, not only the California MBA, but a lot of other business groups that were opposing AB 1482. We were able to get a 10-year sunset included in the bill. So at least at this point, we'll have an opportunity to probably have some good data on this come 2029, and hopefully defeat any effort to reinstate this rent control bill that essentially sort of rips up the Costa-Hawkins Act provisions that protected the state from massive rent control issues at the local level. So that's all I've got on these bills. If you got any more questions about what we followed this year, you can always go to our website and click on the advocacy tab and see real-time information on the bills and our position and sort of a quick little summary. It's a really good way to keep up to date on what we're doing in Sacramento. So with that, I will turn it over, I believe, to Michael to take us into our first presentation.
Thanks, Dustin. I appreciate that. Appreciate the notice of the webinar next week. This presentation today for this group is pretty short. It's on a case that we at California MBA have been watching. In fact, we filed an amicus brief in connection with it. It's called Taniguchi v. Restoration Homes. Some of you may be following it. If you go to the next slide, I don't know. Let's see. Yeah, there we go. It lists the issue that's presented in the case, and it, as indicated here, if the monthly payments that a borrower fails to make prior to a loan modification are deferred under the terms of the modification, and then the borrower defaults, can the lender servicer require the borrower to pay both the current defaulted payments and the previous defaulted payments as a condition for reinstatement of the modified loan? For a long time, people thought, well, yeah, sure, of course. But this case, so far, is going the other way. What are the facts in this case? Well, the borrowers, as indicated here, entered into a loan modification agreement in 2009, and the key part here is they deferred about $120,000 in delinquency. This loan was badly delinquent, and there was a modification entered into to bail these folks out. It provided, however, that failure to make the modified payments would be an event of default, and that in the event of a default, the modification would be null and void. Of course, the borrowers did default. The lender started to foreclose, and as part of the notice of default, the lender demanded that the borrowers repay the 4 missed loan mod payments, plus late charges, foreclosure fees, and the $120,000 deferred from the previous delinquency. borrower said, no, we're not going to do that. We're going to sue. And what happened was the court granted a summary judgment motion in favor of the lender and said, yeah, they have to pay that $120,000 as a condition for reinstatement. And then they appealed. So if you go to the next slide, you'll see how the Court of Appeal, First District, held. They said, no, we're going to reverse the summary judgment because the loan modification violated Civil Code 2953, which prohibits waiving reinstatement rights. And this is a new one. This is the first time this has come up. And the court itself said this is a case of first impression. And specifically, they held that a loan mod is equivalent to a loan renewal under Civil Code 2953. And as a result, that provision prevents the borrower from waiving his or her right to reinstate as part of the loan modification. Now, I'm going to give you a copy of 2953 in a little later slide here so you can kind of see what they're talking about. And the court said that the provision of the loan modification agreement that required the borrowers to repay the deferred amounts was unenforceable. According to 2924C, it can only require reimbursement of the 4 missed payments. It's really unclear where they got the idea that they could just say, regardless of what the parties agree to, they're basically saying, no, you can't enforce a contract between the parties. But that in a loan modification context. But that's what they were doing. This is not the initial. This isn't the initial loan situation. This is a party who's in default on a contract obligation already, and as a condition for forbearance, essentially, they put in there that the payments that were missed have to be repaid in the event of a default. The court said, no, we're not going to allow you to even enforce that. So Restoration Homes asked for rehearing, and it was granted on May 22nd. And it's listed here what the question is that they're addressing, which the court left it open to have a number of questions addressed, but the main one is whether Civil Code 2953 applied to the loan modification. We joined with the California Mortgage Association and the United Trustees Association in filing an amicus brief on behalf of the lender. The brief was written by Wright, Finley, and Zach with input from other attorneys, including our firm. And but there's no hearing date currently set. And as a result, we're still waiting to see how the Court of Appeals is going to handle this rehearing. They have allowed a rehearing, so obviously there's some issue as to whether or not their opinion was correct. And if you go to the next slide, we'll talk about some of the reasons why they're beginning to have second thoughts of this. That's the text of Civil Code 2953, where it says any express agreement made or entered into with respect to the making or renewing of any loan, whereby they agree to waive their rights, shall be void and of no effect. And that's the statute on which the court is hanging its hat. But in my opinion, they've stretched the word renewing or making. We'll see how they go. The next slide, please. These are some of the consequences. If the decision stands, it will obviously reduce the incentive for borrowers to honor their loan modification agreements, particularly if there's a large history of delinquency. If once you get a lender to sign a loan modification agreement that basically changes the terms of your repayment schedule, boy, you're in great shape, because you can default on that, and the lender has then substituted a piece of paper for all of its rights to recover for the past delinquencies. And I don't know anybody in this industry, lender or servicer, who would be happy with that. And so I think that's going to significantly reduce the incentive to enter into these loan modifications, and actually decrease foreclosure avoidance options for borrowers. Bob Finley over at Wright, Finley, and Zach says also that this principle or this ruling is already being used by debtors' counsel to argue that these same principles should apply in bankruptcy Chapter 13 plans. Basically, saying that any deferred amounts under the breached plan are not recoverable. Again, opportunity for a lot of opportunity for abuse here. And so this has piqued the interest of some of the bankruptcy judges who've stayed various proceedings pending the briefing and the application of Taniguchi to bankruptcy plans. Next slide. So that's a promotional slide, but so that's my report on that case. We'll let you know as soon as anything comes out, and there's no hearing date scheduled for it at the present time, Dustin, or Jared, I'm sorry, and but as soon as it does, I think it's going to be significant either way.
Excellent. Thank you so much, Michael, for that. It's, of course, always interesting to find out what's going on in the courts, and sometimes a little bit befuddling, to say the least, but I appreciate the clarity and the leadership that you guys are providing in trying to fight the good fight on that one. Coming up next, talking about yet another interesting fight that's going on, Ken Markison is going to tell us a little bit about what's going on with the GSE patch. Ken, take it away.
Well, thank you. Yes, big doings, I would say. We're at a pre-proposal stage in the CFPB as an industry. What's happening is a clear statement that the Bureau wants to end the GSE patch. This implies a need to revise the qualified mortgage requirements. And what this really does is put the credit box in play again, which of course has ramifications for all of us. Well, let's jump into the slide. Next slide. What we're talking about here, and we'll try to even allow a few moments for questions. July 25th, the Bureau announced in a press release and in an ANPR, or Advance Notice of Proposed Rule, that it was going to work on the temporary patch, that is, allow it to expire and open up the discussion of what the QM ought to look like in its place. We're going to touch on why it's important. We'll jump back in time briefly to look at non-QM, what the general QM requirements are today, what the temporary patch or GSE QM has been. Why is the CFPB doing this? What questions they raised, and basically what some of the thoughts in the first round of commenting, which came in September 16th, and where we might be going from here. Next slide. So, July 25th, clear statement, ANPR, the Bureau made clear that the patch was to expire in January 2021 as scheduled, or possibly after a short extension. So here we are in October, 13, 14 months from now. We'll be looking at a world where no longer are loans that are eligible for purchase or guarantee by Fannie or Freddie eligible for the QM, that is, unless they meet other standards. Today, it's automatic as long as they are eligible to be purchased or guaranteed. According to the ANPR, and this is a comment that we see, the Bureau recognizes that GSE loans represent a large and persistent share of originations. Actually, it's north of 50%. The real question that we'll get to is how many loans wouldn't make it but for the patch, and we'll talk about that in a moment. But the big surprise was no more patch, we're going to let it expire. Next slide. Well, why is it important? I think I touched on it a moment ago. What's really happening with QM is that QM has come to define the credit box. And non-QM loans, while they exist, are proportionally much smaller than the total originations. Just to give numbers, the Urban Institute estimates that there are about $10 to $20 billion worth of non-QM originations last year, or I believe 17, but of a total of 1.8 trillion in originations. These are big numbers, but 10 billion as compared to 1.8 trillion is a small number. Earlier this year, the Bureau, as was required under Dodd-Frank, released its assessment of the ATR QM rule, and that's where it first used this very large and persistent share, but it did not signal that the patch would end. I think what's crucial here is that when we look in a moment at the requirements for the QM versus the non-QM, the presence of the 43% DTI requirement in the QM has limited how many borrowers can avail themselves of QM loans. In fact, about 1/6 of the QM market has DTIs above 43, and the way they become QMs is by meeting the GSE's other requirements. So we're looking at 1/6 of the market in play. Next slide. Very quickly, under the Dodd-Frank ATR QM rule, loans can be made that are not QM. They have to meet 8 factors, including income and debt verification, employment, and other requirements. But if the lender fails to hit the stops, so to speak, and make a determination of ability to repay based on those factors, then significant liability can occur, including a defense all the way to foreclosure. The alternative that the industry, as you know, has gravitated to is to originate a qualified mortgage. Now there, you're limited. You can't have a loan with risky features, but by meeting the cookbook test, you get a safe harbor or a rebuttable presumption of compliance, depending on the pricing of the loan. Just quickly, next slide. The general QM was intended, when the rule was written back in 2013, to be the general cookbook. It sets out the risky features that can't be included, term greater than 30 years, neg am, balloon payments generally. It also, by the way, should say, it limits the points and fees that can be charged to 3% of the loan amount, or slightly higher numbers for smaller loans. The kicker, though, as I said, was that in the general QM, the DTI ratio of the borrower could not be greater than 43%. To calculate DTI, what also became a nettlesome point for the general QM was Appendix Q, which was taken from FHA underwriting guidelines at the time of the 2013 rules. Now, there are other kinds of QMs. We don't have time to discuss all of them. Small creditor QM, VA, FHA, RHS. But the big picture, the big number, was to be encompassed in the general QM. Next slide. But at the time the rule was originated, there was some degree of discomfort with the standard that was being laid out in the general QM, and as an alternative, and because the market was still recovering and still somewhat unstable, the notion of the patch QM was introduced. It had no set limit for DTI, except the limits which the GSEs embedded into their algorithms and models. And so by qualifying to be purchased or guaranteed, a loan met the QM test. Safe harbor, rebuttable presumption still provided. What you have is an industry that in many cases, because of familiarity with the automation of the GSE systems, gravitated to the patch or temporary QM. Next slide, please. So if it's the way I've discussed, why end it? I think the Bureau made clear in the ANPR that, first of all, it did not make or intend to make the provision permanent. It was a 7-year term, or if the GSEs left conservatorship, it was to end. Today, the Bureau expressed concern about reliance on the GSE's underwriting standards, arguing that their continued tie stifles innovation and the development of a competitive private market, I think read QM or non-QM, and it prevents private securitization to rebound. That's been a big problem in non-QM lending. What they also said in the ANPR was that so far as the effects of allowing it to expire, they thought it would result in increased FHA lending where there is not a DTI requirement, but you can be QM. An increased private non-QM market where there is, of course, no DTI requirement. And then I think probably a less fathomable point was that they indicated that many borrowers would simply choose lower loans so that they could get through with a QM loan rather than not. I think, though, that the elephant in the room that is here is this issue of GSE reform. The Bureau, excuse me, reflective of the administration, wants to untether from the GSE relationship as it currently exists. And for those of you who have spent some time looking at the administration's proposals and other proposals, it's evident that the idea of tying themselves to the GSEs as part of this rule is not something they want. In fact, when you look at the material that came out a month or so ago on GSE reform, it highlights the end of the patch as an important point. Next slide. Let's talk quickly about the questions in the ANPR. The ANPR talks, as I've suggested, about the world as it is now, but it says recognizing that the patch will go away and it will have an effect. What's to be done about the general QM? Specifically, should the DTI ratio be retained? Should it, if it is retained, be at 43? Should it perhaps include some other factors or compensating factors? Some folks talk about reserves as being a possible compensating factor. What about Appendix Q? Nettlesome, not well understood, not well used. Should it be retained, changed, or supplemented? In lieu of maintaining the DTI ratio, should the rule maintain statutory restrictions on risky features, underwriting requirements that exist already, the no neg am, the points and fees limit, and eliminate the DTI requirement altogether? Another suggestion is maybe just for higher priced loans, you maintain a 43% ratio, but not for garden variety prime loans. The Bureau should retain the safe harbor. Big question. Is the safe harbor metric right? There are those of us who think that a hard look at the safe harbor would bring a good deal more lending. That is to say, if the safe harbor were extended. Finally, if we're going to make this transition, what amount of time is needed to make the change? Jump to the next slide. Well, the comments are pretty self-explanatory. You can imagine a lot of folks want to drop the DTI entirely. They think the reliance on statutory restrictions would be sufficient, and if it went with a safe harbor rebuttable presumption standard of, say, 150 above being the rebuttable presumption and below that is safe harbor, what you'd have is that the finding or determination of rate, which includes DTI, which includes assets, which includes employment, income, would be a better metric. So why get sidetracked with the DTI altogether? I think in the comments, there was a recognition of how important the patch is. The GSE systems work, they're dynamic, they're ubiquitous. We have to make sure we're going to a good change. The suggestion in many of the replies, I think, has been that the Bureau should extend the patch until there's a better mousetrap. Next slide. I think since they're opening the discussion, other issues are likely to come into play. How affiliated settlement services are treated in the points and fees. If we retreated from the DTI, points and fees becomes more crucial. Interesting. Another issue that's bubbled back to the surface, and I think most people don't know about, is that the sunset is not only applicable to the patch, but the limited cure provisions, which allow cures of loans to allow them to be QM based on mathematical errors, sunsets as well. There are comments that seek to stop that from happening. And of course, safe harbor, which I discussed. Next slide. Closing. Well, next step here is that we'll be seeing a proposed rule. And I think it'll be informed by a lot of what already has been said. It is possible here that this whole effort might result in a much more streamlined general QM without a DTI requirement. But I think one should notice that there are also folks who have the ear of reporters and others who are saying that the administration is being pressured to dilute the requirements for QMs and bring us back to a crisis again. There was an article like that recently in the Washington Post that could actually have the effect of perhaps changing the discussion or maybe even calcifying it. Not one article, but if the sense is that the changes here are dangerous, they may infect the political process. I would hope that at the next stage, we'll have an opportunity for the public, for the bar, for commenters to access data on default, so that when we're talking about adding this factor or that factor, what we're really talking about is why. Why is it necessary? What does it take to assure qualified mortgages to creditworthy borrowers? That's the riddle. The stakes are high, as we indicated. The patch, along with the rest of the QM, has defined the credit box, and this important work has to get done before it goes away. That's my take on this, and I'm happy to answer any questions if there's time.
Excellent. Thank you so much, Ken, for a very detailed and helpful and insightful explanation of what's going on with the GSE patch. That again is just a very, very interesting and confusing and complex area that I think you've made very, very clear what's going on. I really appreciate that. Coming up next, Abe Salen from the Wolf Firm to talk to us about recent developments in vicarious liability and how liable our lenders really are for their employees. Abe, take it over.
Yes, thank you, Jared. So very quickly, I want to be talking about what gets potentially lenders and possibly servers into trouble in the court system. A recent case came out earlier this year that talked about the issue as to whether or not a lender or a creditor can be liable for the subcontractor's wrongful conduct in performing actions on behalf of that creditor or lender under the Telephone Consumer Protection Act of 1991 as amended. Let's go to the slide, please. And go to the next one. So we're looking at 47 USC section 227B, which says that it's unlawful to make any call other than with the express consent of the called party, using any automatic telephone dialing system or an artificial or pre-recorded voice to any telephone number assigned to a cellular telephone service. They also can't use skip tracing to try and find your numbers if you haven't consented to them calling that number, okay? There's a case that came out in March of 2019. It's called Henderson versus United Student Aid Funds, or USA Funds, Inc. The site, by the way, is 918F3D1068. Again, it's a Ninth Circuit case out of March 2019. I'm sorry I didn't put that in my slides. I just noticed that. So USA is the holder of a bunch of student loans. It hires Navient, the servicer, to collect the unpaid student loans. Navient, in turn, hires independent contractors to go out and make phone calls to try to collect the debts. In this case, the plaintiff, a former student who had a loan, contends that those independent contractors unlawfully contacted her numbers that she didn't allow authorized. And so initially she sued all three, but she couldn't get personal jurisdiction over Navient or most of the independent contractors. So she was able to sue USA, claiming a violation of the TCPA. Please go to the next slide. In this case, facts are everything. USA had access to Navient reports and tracking collectors' performances, but even though they audited Navient practices annually, they did not look for TCPA violations and did not have a policy that they provided that required Navient to provide them with compliance measures as to its loans. As a result, the district court, which was the Southern District in California, granted USA's motion to dismiss, claiming that it had no direct contact with the borrowers, and it had insufficient contact with the collectors, who were actually subcontractors to Navient. Go to the next slide, please. The Ninth Circuit reversed, and what they looked at was common law vicarious liability. As we know, vicarious liability says that a principal may be liable for the conduct of its agents. Most oftentimes, this is in an employer-employee relationship. In this case, it dealt with the independent contractors. And specifically what the court looks at in terms of the federal common law is whether or not the principal ratified the conduct of the agents or provided them with actual authority. Please go to the next slide. Importantly, USA tried to say that its contract with Navient explicitly set forth that it was an independent contractor and that USA had nothing to do with how it approached collection. And the court held that that was irrelevant in its determination as to whether vicarious liability applied. This is becoming obviously a big issue in California, as you'll hear next week with AB 5, which sort of codifies the Dynamics case out of the California Supreme Court last year, which really narrowly focuses who it may be an independent contractor and who cannot be. But in this context, regardless of whether they are independent contractors or not, the court said, did USA Funds ratify their conduct by doing something or by not doing something? So go to the next slide, please. In this particular case, USA knew of the conduct of the agents because it reviewed the call logs periodically. In addition, and quite frankly, the court really honed in on this, the third-party callers represented to potential borrowers that they actually were affiliated with USA Funds. In that instance, the court held that it should be left to a jury to decide whether the facts sufficiently upped the ante, if you will, and created vicarious liability, and therefore the motion to dismiss was improper. Please go to the next slide. Interestingly, in this case, there was a strong dissent by Judge Bybee, who held that the facts did not support the conclusion of the court. However, I think that the dissent actually agreed with the majority in terms of what factors would be relevant. In other words, whether there was actual authority or ratification. In this case, Judge Bybee said that there wasn't sufficient factual context, but there aren't sufficient facts to overturn the motion for summary judge, or the motion to dismiss, excuse me. But he held that you could ratify and you could provide actual authority. So please go to the next slide. So what's the impact? I think that private and small lenders who really rely upon independent contractors and servicers to do their bidding should really take heed with these cases, because while this case focuses on the TCPA, there are cases out there that, like RESPA and focus on RESPA and the FDCPA, where you could see a court rule that the creditor could be liable for an independent contractor's conduct. course, recent cases, the Christiana Trust case, Fifth Circuit of 2018 indicated that RESPO was limited to servicer misconduct and therefore there wasn't vicarious liability. However, the Seventh Circuit in 2016 held that there could be vicarious liability to some FTCPA claims, depending on whether or not the creditor conducted itself as a debtor, as a debt collector on its own. Again, I see this as a grave issue for creditors who hire independent contractors to do their work for them. Anyway, that's what it is, and we'll look forward to see how courts rule in the future. Thank you.
Excellent. Thank you so much to all of our presenters. Again, Abe, thank you for speaking on this very, very important issue that's developing. We're coming up close on our hour, so I'm going to run very, very quickly through another case that has come up recently that we all think you should be aware of. I know we've had many, many webinars on the idea of the California duty of care and really where it stands. And it's been developing over many number of years and kind of expanding. Next slide, please. That first slide, Biakanja, Irving, and Nymark kind of tell you what the old rule is. And the old rule basically was no duty of care when it deals with loan modifications. Anything beyond your typical scope, maybe there's a duty of care, but loan modifications are a typical duty of scope of what a lender actually does. So we're not going to apply duty of care. As you all know, Alvarez and Daniels many, many years ago came back out and said, well, okay, but we're actually going to see that or say that a loan modification is beyond that typical scope and therefore apply a duty of care. And the whole idea behind it was, geez, the banks, as I think Alvarez put it, hold all the cards. Next slide. Recently, Shane versus Wells Fargo Bank came out. This just came out in August, and it kind of turned everything back on its side. Shane recognizes that there is a huge division between the California courts as to, whether we're going to follow Luares and Nymark or are we going to follow Alvarez and Daniels, and notes the California Supreme Court has not resolved that and opts to follow Nymark and Luares again. It's citing a couple of cases that came down in 2019 called the gas leak cases that's dealing with it in a non-loan modification sphere. What duties apply and whether or not there should be a tort duty in a contractual basis nature, noting that a majority of the states simply don't apply such a duty. Next slide. So Shane comes down on the issue of basically saying, listen, even in a really, really bad factual scenario that frankly is worse than the factual scenario that existed in Daniels, where for example, in Daniels, all that happened was the borrower alleged, I was current on my mortgage until my lender told me not to be current on my mortgage in order to qualify for a loan modification. How often have we heard that allegation? In Sheen, it was much worse. In Sheen, the foreclosure of the second happened after the borrower was told that the second wasn't going to be foreclosed upon. The only real notice the borrower alleged that he had was that, your home's going to be sold today. The court nonetheless expressly disagreed with Alvarez and Daniel, found expressly that a lender does not owe a borrower a tort duty of care during a loan modification agreement or negotiation, and actually even went as far as to call the Biakanja factors debatable, which I think is actually a very good step in the right direction. Next slide. And again, kind of goes through the history of all these various cases. Sheen is just a wonderful case to kind of discuss where this law has been and where it's headed, and setting up that discussion basically for the California Supreme Court to make that decision of whether we should follow Alvarez or whether we should follow Nymark. Sheen comes down very decisively on the side of Nymark, notes that there's 23 state supermajority block of a dominant position holding that there's no duty, that the reinstatement basically holds there should be no duty, and basically finds that Alvarez was wrongly decided. It even does this in light of my very last point here, does this in light of the fact that it says that, the alleged responses to Sheen's loan modification request may have been confusing, confused, tardy, or flat wrong. but there's still no duty of care. I think this is very much an encouraging development in the duty of care field that still is very much evolving. You should all be aware of this and see where it's headed. Keep your eye out for new duty of care cases, and hopefully we'll continue to see the trend moving back towards NIMARC and Lueris. Okay, with that, we'll open up for any questions that we have. Again, there's a dialog box over on the right-hand side there to your screen that will allow you to submit any questions as well as talk about them. And Dustin, I don't know if you had any other comments.
No, and I don't have any other, I don't see any questions at the moment, but I would just again remind everyone that we've got our AB5 webinar next week. Registration on our website right now, cmba.com, and then of course our legal issues conference, as Jared mentioned so well in the beginning, December 2nd and 3rd in Newport Beach. And as he mentioned, sponsorship still available, and certainly register for that conference is going to be great. We're going to have Terry Theologis from Fannie Mae and Manny Alvarez, the new commissioner from the Department of Business Oversight here in California. So I see a question here, Jared. It says, and I'm not sure who wants to take this one. Oh, you know what? I apologize. That's not a question here. That's a comment. Comment saying we did a great job. Sorry about that. So Jared, I don't have any, I don't see any questions here. So looking at the time here, looks like if you want to wrap up, then I think
Excellent.
we're able to do that.
Excellent. Well, again, thank you to everyone who participated in today's webinar, not the least of which is all of our presenters, Michael, Ken, Abe. You all are fantastic. I greatly appreciate, again, the opportunity to serve as chair on this committee and, following in the footsteps that are very, very large footsteps that Michael left. Michael, you've been, of course, fantastic for the CMBA committee, and I really appreciate, again, the opportunity to step up and try to fill in that shadow a little bit. I look forward to Ian's leadership in the upcoming year. I know he's got a lot planned that's going to be fantastic. And again, if you all are interested in joining, please reach out to Dustin. I'll make one final pitch on this legal issues committee, conference that's coming up in December. Sponsorship includes, in many cases, registration. So please, if you're interested in registering, spend a little bit of extra money, sponsor it, and get your name out there as well. Thank you so much for attending, and have a wonderful afternoon, everyone.
Thank you.